Hey, welcome to today's video. Today we're taking a look at a case where the DMCA immunity provisions were waived because some defendants failed to comply with the technical requirements of the law, which involved designating an agent. And so specifically, this case involves celebrity fan sites. So I'm Rick Chapo. I'm with DMCAagentservice.com. We provide third-party agents to website and app owners who want to comply with the DMCA by designating an agent, but don't want their personal information listed publicly. So the case at hand here is BWP Media versus Hollywood Fan Sites LLC. The name's a little misleading because there were actually three defendants in the case, the parent company and then two subsidiaries. And so what was at issue in this case was whether the defendants had complied with the technical requirements of the DMCA. So just as a primer, the DMCA gives websites online, as well as apps, immunity from liability for copyright infringement if the claims for copyright infringement are based on content uploaded by users. So let's use an example. This video, when I'm creating it, my intention is to upload it to YouTube, to our homepage on YouTube. Now, if there's something in the video that constitutes copyright infringement, let's say this little guy on the right, my use of him, maybe I'm using him without permission or something of that sort, well, I could be sued for copyright infringement. But can YouTube? And the answer under the DMCA is no. YouTube has immunity from liability. Now, there's a catch. It must follow a particular compliance procedure detailed in the DMCA. And so if you try to get the immunity of the law, you have to follow it as well. And that's where things started going poorly for the celebrity fan sites. So in this case, we had three defendants, a parent company and what appears to be two subsidiaries. And they were running about 4,500 different celebrity fan sites. And these sites allowed fans to come in and upload content. And as you can imagine, when it comes to celebrities, they were uploading quite a few images of the celebrities. Now, most photos of celebrities are taken either by professional photographers or by the paparazzi, and they tend to be pretty valuable. You can sell them to tabloid companies and what have you for a good amount of money. And so these photographers, whether they're paparazzi or not, tend to be very aggressive when it comes to protecting their content. And that's what happened here. The photographer was actually out looking around and found these sites and saw his content up there, and then probably went ahead and tried to file a DMCA takedown notice, but couldn't find the agent for these sites. And then a light bulb went off at some point, I assume, and realized that the sites had not designated an agent, which is a technical requirement of the DMCA. You must do it. There is no workaround. You can't take a shortcut here. You can designate yourself. You can designate a service like ours. You can designate your attorney. You know, there's a variety of ways you can do it, but you must do it. And so in this case, the lawsuit went ahead. It was in New York, and discovery was undertaken. And what was finally discovered and agreed upon was that the parent company had, in fact, designated a DMCA agent in a timely manner, but the subsidiaries had not. And so what happened was once the lawsuit was filed, they went ahead and filed for agent status. They registered their agents at that point. And the question that was presented to the judge in the case was, well, have they waived their immunity and when? And what the judge ruled was basically that once those subsidiaries designated the agent, the immunity was back in place because at that point they had complied with all the requirements. However, for the time period that the websites were up prior to the subsidiaries designating their agents, they had waived the immunity from the DMCA. So for that whole number of years where people were uploading photos of celebrities prior to the subsidiaries designating their agents, they were going to be held liable with their users for copyright infringement. And so that was a very bad day for those subsidiaries because, again, the value of celebrity photos is pretty high. And so they were looking at massive damage claims there. And this ruling is accurate. There's nothing controversial about this ruling. These sites, the companies that own these sites, they just blew it. And so the lesson you should take from this case is that if you own a website or an app and you're going to allow people to upload information to it in any way, shape, or form, even just comments, you should comply with the DMCA. It's a get out of jail card. The compliance cost is incredibly cheap. It's $6. That's how much it costs to register with the Copyright Office. If you want to use a third-party agent service like ours, we charge $70 a year. That's nothing. Nothing compared to the cost of an infringement lawsuit. You're going to run up $50,000 to $100,000 just in defense costs, and attorney's fees trying to defend the case. And then, God forbid, you actually be found liable, and you're going to be looking at an even larger judgment. So it's kind of a no-brainer. But the key here is you have to understand the compliance process, and you have to follow it. You have to designate an agent. You need to come up with a repeat infringer policy. You need to have a plan in place for when complaints come in. How are you going to handle them? All these requirements. Now, it's not difficult. You can find guidance online. You can go to our website at dmcaagentservice.com and find a guide. You can buy books on Amazon. There's a book called the DMCA Handbook. You can purchase that. So there are different ways to learn how to do it. You can even have your lawyer do it, whatever it is, but do it. Don't be like these guys who failed to take a step and then faced, many hundreds of thousands of dollars, if not millions of dollars in potential damages. You don't want to make that mistake. So that's the lesson from this case from BWP Media versus Hollywood Fansites LLC. Make sure you cross your T's and dot your I's when it comes to DMCA compliance. So if you have any questions or comments, just post them below. I'll be happy to answer them. If you're interested in the DMCA and copyright issues, we hope you consider subscribing to our channel because we'll be posting videos constantly on those topics. So have yourself a good one. And again, thanks for watching.